A little intro first. My name's Renee Bauer. I am the founder of Happy Even After Family Law. I am have been practicing 23 years now, exclusively in divorce and family law space. The firm practices all over the state of Connecticut, and we cover everything from restraining orders. Oh, we have more people coming in. Okay. Um, Bear with me for a minute as I just want the person who just came in to hear what I had just said. So if you just joined, I am recording this, and if you see everyone else just put their initials up, so identities wouldn't be known. I recommend you just keep the camera off for this portion of it. Then I'll stop the recording. I'll open it up to the floor, and you can certainly turn your video on. And if you're comfortable asking questions and you want to do that, you can. And that part won't be recorded. So let's see. We'll keep going and see if anyone else joins us. So like I was saying, I've been practicing 23 years. My firm practices in the entire state of Connecticut. We have offices in Hamden, West Hartford, and South Norwalk. We do everything from restraining orders to custody cases to high complex asset litigation, uncovering hidden assets, narcissistic abuse, all of that. So I wanted to do this as a give back to the community and anyone feeling like they were uncertain and didn't know what was next in their journey. Often law firms will charge for consultations, and at that time, it gets very specific into what's happening in your life and in your world, and you ask those specific questions. But I think there's a lot of misinformation out there. I think a lot of times people turn to like Instagram to get advice about divorce and so I wanted to offer something that was just really more educational and to give you an idea of what to expect. So that's who I am. I also created a app called Parent Copilot, which is to help parents communicate with each other and defuse texts that might come through or emails that might come through. It's a free app on any of the Apple or Google store. It was about a year ago, a client reached out to me asking me to revise emails between him and his ex. And I thought to myself, there has to be a better way of doing this, which is the reason why I created Parent Copilot. So what we're here for today, though, is to talk about all of your divorce options, to think about not every divorce is exactly the same. And I think a lot of times when someone's going through a divorce, they often turn to family and friends and the internet to try to find information. And your best friend's divorce might look very different than yours, and the type of divorce and the process might look very different. So we're going to talk about all of the different options. And why it's really, really important to get clear on which option is the best fit for you now before the divorce is filed, rather than later on when you're in the midst of it and change your mind and say, we want to switch up the process. So there are a couple different options that you have before actually get to the end of your divorce. So the typical one that most people think of when they're getting divorced is did that change for you, Julia, the screen at all? It did. Yeah, it changed for me too. Is it back? Do you see the?
Yeah, I see the divorce options.
Okay, okay. I clicked something, so I don't know what I did to it. So the first one is litigation. You're going to think about litigation as your typical, you each have lawyers, maybe someone is pro se, but you're filing the paperwork, you're following the court process step by step to get you to the end resolution. What that process looks like in a typical litigation. Now, keep in mind, this is the Connecticut process. And if you hear from a different state, sometimes, most states will have a different version of this. They're all very similar, but it just might look a little different, or there might be a little bit of different terminology. But you're filing a divorce complaint. That's the thing that starts the divorce. A common question that we hear from people is, does it matter who files for the divorce first? And the answer is, no, usually. The only time that it would matter who filed for the divorce is if you get to the point a year down the road, you haven't been able to reach an agreement, and you have to have a judge decide how you're dividing assets or what a parenting plan looks like. You have to have a trial. And then at that point, the plaintiff, the person who brought the lawsuit, gets to tell their story first. We have someone else joining us. Okay. So they get to tell their story first, meaning that they tell the judge, here's what happened in our marriage. Here are all of the things that I'm asking the court to consider. And then the other side gets to go. Does that matter much? And from my shoes, I'd rather be the person telling the story and framing what the relationship looks like. But at the end of the day, the judges know what they're doing and what facts they need in order to make a decision. Keep in mind that if you go to a trial for divorce, there isn't a jury. It's made by a judge, and the judge is the only one making that decision. So a little bit different than like a criminal law. So it's that question, does it really matter? It doesn't. Sometimes it's more of an emotional decision that they don't want to be the one who files because they didn't want the divorce, and they tell their spouse, you file. The cost wise is very minor. So the filing fee is $360 that the court, just to file the paperwork that the court takes, that person who files has to pay that fee. Usually the attorney who drafts it, you're paying for those legal fees for the attorney to draft the motions, the documents as well. So litigation, the case is filed. The first thing that happens in Connecticut is the court's going to schedule something called a resolution plan date. That's about 60 days out. That means that you're going to go to court with your lawyer if you have it. If not, you're going to go representing yourself pro se, and you're going to meet with family relations, and they're going to say, what's going on in your case and what do you need from us? And at that point, the court's going to evaluate whether your case is a high conflict case or likely to resolve, or somewhere in the middle, where most cases fall. So that middle path means that they're going to offer you some level of services in order to help you move your case closer to an agreement, recognizing you're not coming in on day one saying, we have resolved everything and we don't need anything from you. And we'll talk about that. That's usually the path if you're mediating. So let's assume that you're on that middle path. The next thing that will happen is the two of you are going to exchange financial documents. Financial affidavits have to be filed with the court no matter what. Financial information typically gets exchanged, such as tax returns and bank statements and credit card statements. And a big one now is crypto. Being aware if a spouse is trading in crypto or mining in crypto, has a Coinbase account, a Robinhood account, things like that. That tends to be the item that I could talk about crypto all day, but it tends to be the thing that people, if they're hiding something, it's where they're hiding it, is digital assets. And so paying attention if your spouse is talking about buying Bitcoin or anything like that. So the financial information is being gathered and exchanged. So the two of you know everything that there is to know about your marriage and the marital pool of funds, so to speak. And then the next thing would be trying to negotiate a settlement. And that could be done through family relations, going in and sitting down and saying, we have some issues with custody or parenting plan, and we need help with that. And family relations can help you put together that parenting plan. Sometimes the lawyers will do it without family relations. Or if you need help with the financial part of it, the court will schedule it for a pretrial. That means everyone's going to court, sitting down with the judge, and the judge is looking at the numbers, looking at the finances, looking at those financial affidavits, and saying, here's my recommendation to resolve the case. Most cases settle soon after that place because everyone has heard the recommendation straight from a judge as to what should happen. Everyone comes back to the table. Maybe you're tweaking or refining those recommendations to make it work. The agreement's getting written up, signed off on, submitted to the court, and then you're getting divorced. The only good thing that came out of post 2020 was that you no longer have to go to court to get divorced. You can file all of your paperwork online, and the court can grant your divorce without you stepping foot into court again. So that's the way of litigation. So even though litigation is typically sounds a little bit more adversarial, most of those cases still get to an agreement. The next step is mediation. So mediation is where the two of you are going to hire an unbiased person to mediate your case. They're going to be someone whose job is not to tell you what to do, is not to be a judge. It's to help facilitate a conversation about how to divide things and how to create a parenting plan if that's what you need. They should be an attorney. In Connecticut, you don't actually need to be a lawyer to mediate. I caution you on that because there are a lot of things that are very dynamic in the court system, a lot of things that are changing. For example, the court has changed the child support, when child support deviations are appropriate, meaning that when does child support not get paid and what can people agree to not do. And if you're not in the court system or constantly staying on top of things like that, then you may have an agreement that the court rejects because it doesn't fall within what the current case law says. So your first step is mediation is to find a mediator who both of you are comfortable with. I always suggest that you go and meet with this person together. Sometimes someone will come to us and then say, I think I want to mediate. Can you do it even though I've just met with you? And even then we like to reach out to the other side or have them call us and to have a conversation so that they're comfortable as well. There has to be buy-in between both of you. You both have to feel like this particular mediator is a good fit. So the pros of mediation are that you are controlling the timeline. So you're not filing your divorce paperwork while the mediation is happening. You're doing all of the back end negotiating. You are doing all of the financial piece of it. The drafting of the agreement is being done by your mediator. You're having sessions. And then when you reach a final agreement, all of the paperwork's getting drawn up, submitted to the court at one time. The court will then review it and likely grant your divorce on the papers, meaning that you don't actually ever have to step into court, which is a wonderful thing for most people. Sometimes the court will have questions, and every once in a while, we'll see the judge call the couple in to answer those questions, and sometimes call the mediator in if there's something really complicated or complex about the agreement and the judge has questions about that. They're going to want to hear from both of you. Now, I always say with mediation, even though you're hiring this person to mediate, you each should get review counsel to review the agreement, because the mediator's job is not to advocate for you or to tell you if something looks unfair. They're supposed to reality test. They're supposed to say whether something is practical. They're supposed to say whether they think it's going to pass muster in the court, meaning that the judge is going to find it fair and equitable and just. But sometimes that doesn't happen, and sometimes people reach an agreement and there maybe one person has agreed to something that they shouldn't have, and so you really should have review counsel looking it over. It's worth the little bit of money that you pay someone just to review the documents, review the numbers, independently run child support numbers, for example, and make sure that they match up to the numbers that the mediator has run. And just review the language and make sure there isn't anything gray in there. Their job is not to cause a stir or to upset an agreement that was already reached, but just to bring talking points back to the table that might be something that come up with a point that maybe no one's thought about, or at the very least, someone that you can go to say, can you explain these provisions to me so I really understand what I am signing? So mediation is done on your time. It's definitely going to be cheaper. Most mediations should be done between 2 to 4 sessions. Very, very rarely have I seen a mediation go longer than that. And if it's getting to the point where there's 6, 7, 8, 9 sessions, you're probably at that end of the road where mediation is not the best path for you. And maybe you need to get lawyers involved. So also be wary of a mediator who says that it might take 10, 15, 20 sessions. Like, I've seen a mediation take someone a year to do, and when it came across my desk, I was like baffled, because mediation should not take a year. The whole point of it is to move the process along a little bit quicker, and not take as long as litigation. Okay, number 3, the collaborative divorce process. This is a little bit different. It's another adversarial resolution, or non-adversarial resolution process. So the point is you're keeping it out of court. The two of you are going to get your own lawyers, and then you're going to typically have a neutral person who facilitates the conversation. So sometimes that person is a mental health professional, sometimes it's a financial person, depending on what the two of you need with your circumstance. So let's say parenting is not an issue, but finances are. You probably want that third person to be a financial person. So part of the collaborative process is everyone signs off on an agreement at the very beginning that says we will not litigate. We will not bring it to court. If this process doesn't work, the lawyers will back out. You'll have to go get new lawyers and start with the litigation process. So this can be a really useful process if you want the representation sitting next to you in the room for the meetings. I like it if it's a little bit more complex with finances. It doesn't mean it's going to be cost effective or shorter, because there's a lot of meetings, because there's a lot of moving parts and a lot of people. And if it's a highly contentious situation, sometimes this isn't the best process, because what it does is it forces people to feel like we need to reach an agreement, because if we don't, we're going to have to start all over again and get new lawyers and spend more money. So I always cautious people to evaluate whether this is the right process for you. But it is good for those that make it work. It's a very good one in order to keep it out of court and have a judge make decisions for you. Also to note with the collaborative, not every lawyer does collaborative divorce. If you decide to go down this route, I would suggest you find a lawyer who has been trained in the collaborative process, because it's very different. And you really want someone to come to the table with the mindset of what this process is intended to be, and not have it be collaborative that feels like partially adversarial, and you have someone really, really aggressive, and it defeats the whole point of what this is. And then the last one is the pro se. So this is do it yourself. This could also be just like document prep. You have an agreement with your spouse. You don't need lawyers to negotiate anything, but some people will just fill out the paperwork themselves, submit it to the court. Other people will hire a lawyer just to prepare the documents and make sure that the agreement is written in all the standard forms and just submitting it. So these are the two cost-effective ways to get divorced. The pro se, my one word of caution is, if you and your spouse are going to file all of your paperwork, I would also have review counsel review it, because you want to make sure you don't have loose ends and have things that are unclear, and then you go to enforce it and no one knows how to interpret it because it's not clear on what that says. So for example, I saw recently someone did a pro se and they didn't talk about dividing up their bank accounts. They just pretended that they didn't exist. So at the end of it, the divorce was done, and now they were fighting over these joint bank accounts. And the judge comes back and says, well, you never disclosed them. It's not in here. You didn't talk about what you wanted to do with them. And it created a problem. So you just want to be sure that everything that is supposed to be divided is part of this agreement. I don't like the court has forms online that you can fill out, like an agreement form. I do not recommend using them, because they are kind of inadequate about covering everything that you need to cover. At the end of this, I'll give you guys a QR code for a free workbook that will really lay out all of the different things you want to think about. You can use that as a starting point to kind of check off each of the areas that should be part of your divorce. So I kind of jumped around here, the court process. So this is, we talked about this. Your exchange, the idea is that everyone's fully informed. The financial information is getting exchanged. You're attending court conferences or status conferences that the court schedules if it looks like nothing is happening on your case. And then you have the trial, which is the last thing that happens if an agreement can't be reached. From the time that you file leading up to the trial, though, sometimes people need intervention from the court and assistance with things such as child support, or maybe alimony, temporary, these are all temporary orders, or a parenting plan that's temporary. So you can go to court at any point and ask the court to make temporary orders. So it gives you some guidelines of until we get to the end, here's what everyone is supposed to do. So that's always an option. It's not a requirement, but it's certainly there as an opportunity if you need that. So the point of it really is with all of this is the court's ready to get involved with as much as you need them to. The if you can do things outside of it, then that's always the best process. A lot of people don't ever need the court's intervention at all, which is fine. But not, and this is why not every case is exactly the same. Your neighbor's divorce might look very different because maybe they never went to court once, and maybe you're in a situation where it's high conflict and you need to go to court multiple times. Something that I do want to talk about as at the very beginning of your divorce, there's something called automatic orders that go into place. That means that nothing is supposed to change financially. So the bills are supposed to continue to get paid like they have. No one's supposed to liquidate any accounts. No one's supposed to take a loan on a 401k. The court doesn't freeze bank accounts, but the automatic orders protect things like that. And if someone were to violate that, then you can go to court and ask for let's say they go and withdraw all the money from a bank account. You could go to court and they could be ordered to put that money back. So it's part of that initial paperwork that actually gets attached to the summons and the complaint, which is what it's called, that says here are all of the things that you're supposed to do. You're not supposed to deprive your spouse of access to the kids if they've always had that. So you're not supposed to move out of state if you have kids. Okay. Let me take a moment talking about, I want to do maybe another 15 minutes of so and then open it up. But I want to take a moment to talk about parenting. Do we have any questions? Anyone raise their hand from where we have finances, money? Okay, process. We're good there? Okay. So let's talk about parenting. Custody, what it means, what it looks like, what is a parenting plan? So high level overview of custody. You have joint legal custody versus sole custody. That's one bucket. Then you have physical custody as a different bucket. Those often get mixed up. So joint legal custody means that the two of you are making decisions together regarding health, education, religion, all of the main decisions that parents have to make. The default is joint legal custody. If there's two parents, both parents, the court is assuming, are equipped to make those decisions together. And that would be called joint legal custody versus sole custody, that one person is the sole decision maker. A lot of times you'll see that happen if one person maybe doesn't live around here. Maybe there's a level of conflict that makes co-parenting nearly impossible. And sole custody makes sense because the less interaction that these parents have, the better off the kids are. So that would be a reason for sole custody. Sometimes domestic violence situations, sole custody would be granted to one parent. So there has to be a reason for it, not just that one parent has always done the parenting, which is quite common in marriage. You'll hear one person say, well, I'm the one who did everything. I did the doctor's appointments and the school appointments and all of that. So I should be the final, the decision maker. That isn't necessarily enough to rise to the level of sole custody. But if you have a situation, let's say, where you're the one who does all of the things and the other parent travels 3 weeks a month and isn't around to do those things, maybe it's a situation for sole custody, or maybe it's a situation for joint legal with you having final decision making. So the parenting plan can contain a lot of provisions such as joint legal, final decision making if the spouse B does not reply to the request or the email or the text within X amount of time. So some of those things are really going to depend on the two of you. The higher conflict, the more that you want in the parenting plan. Now you have physical custody. So that's where the kids are laying their heads. So you could either designate a residence or you could have shared physical custody. So that has nothing to do with decision making. That's really just where they're spending a majority of their time. You're going to see when I started practicing a long time ago, you would typically see one home designated as the parent that had custody, and the other parent was like the weekend parent, and then they would have maybe a dinner visit or an overnight visit. That has shifted to more of a shared plan, so long as both people can do it. If the parents have schedules that allow for it, if it's a minimal conflict, that allows for a shared parenting time. If the parties are living relatively close to each other, that makes the shared parenting make sense and is practical. Then you'll see the courts like to default to that. But so the kind of the default is shared and joint legal, and then you move from there. And every situation is really different. So the higher the conflict, you want your parenting plan to include everything such as holidays and how decisions are made and how activities are made and what expenses are going to be shared. Maybe you want a cap on those expenses. Maybe you want a part of the agreement that these are the activities that your kids participate in and they will continue to, and any activities outside of that have to be approved in an approval process. So those are the type of things um, that you could include in the parenting plan. Or if you have a low conflict situation, you might simply say, we have joint legal custody, we have a shared parenting plan, we're going to work together to address the schedule, and it's minimal, and you may never look at that parenting plan again, and the two of you are going to move forward and make decisions and never have to look at that court order. I had someone recently ask me that would they have to go back to court every single time that they wanted to change their parenting plan? And the answer is it depends. So if you have something, so the standard the court looks at is substantial change of circumstances. And that means that has something changed that disrupts the last court order that you have, that makes sense for the schedule or even financial orders to change. Some people are able to work that out and never go back to court or have to file anything. And that's great. That's always ideal. But for others, they need to go back and make sure that it's written down and make sure that everyone knows what they're supposed to do. And they file that motion to modify after the divorce. So you can do that for financial orders. You can do that for custody plans. You can't do that for property settlements, though. So once you make that decision on how to divide an asset, that's the end of the road. You can't go back and decide that you want to do something different, or maybe you want a piece of the business after all. If you've already signed it away, there's nothing you can do about that. So you want to make sure when you sign a divorce agreement that you mean it and that you know everything that there is, because you don't get a second bite of the apple. Okay. How to find the best lawyer for you. So this one is, here's the truth. Not every lawyer is the same. You are going to want to interview a couple different lawyers. I don't think that anyone should just be hiring the first lawyer that they meet, because I think that you have to find the best one for your situation. So, for example, if we were talking about the litigation or mediation or collaborative, some lawyers don't mediate, some lawyers don't do collaborative. And so if you hire a lawyer and they think that they're litigating for you and you change your mind a quarter of the way through and say, I talked to my spouse, we want to mediate, you just lost a lot of time and money. So it's really important to identify which path makes the most sense for you so you can hire the right person to represent you. I think that the questions that are really, really, really important for anyone to ask their lawyer is, what does their communication style look like? This is a big one. Most lawyers who get grieved or get fired, one of the complaints is often that they don't communicate with their clients and they don't know what's going on. And so if you're someone who needs a lot of communication, wants to know what's happening on their case, wants a check-in once a week, you need to be matched with a lawyer who can meet those expectations. Now, it doesn't mean that the lawyer has to be responding to you within 30 seconds of the text or the email, but they should be responding, I think, within 24 hours of you reaching out. And the response could be simply, I'm tied up in court. Let's get something on the calendar for this date so we can talk through all of this. That's a huge one. And I think it's really important to ask that question. I think you should ask the questions of how do you invoice? How often do you send out bills? Because you should be getting a detailed breakdown of everything that your lawyer has done on your case. It should be sent out to you at least monthly so that you have an idea of the work that's being done, how much you're getting charged for it. And if there is an issue, then you can ask the question when it's close in time to when the work was done. Sometimes you see lawyers not send out invoices for, every 4 months. And at that point, how do you, it's hard to go back and look at something that was done 4 months ago and ask the question. The lawyer's not going to remember. You may not remember what it was, what that conversation was about. So that's a really important question. Um, Another really, really, really big one is make sure that you are hiring. We have someone joining us right now, a little late, but better late than never. Make sure you're hiring someone who that's what they do is family law and divorce. The saying goes, Jack of all trades is a master of none. There is truth to that. You do not want a general practitioner. You do not want someone who does workers' comp and personal injury and criminal and dabbles in family or divorce to be your lawyer, because those are the lawyers where you won't often hear from them. They're maybe not catching up to speed on what the new case law is. And so it's really, really important to find someone who exclusively practices in that area. And then making sure that, one of the things I think that is every client's obligation and duty is to get organized and to understand what your goals are so that you can communicate that to your lawyer to say, my number one goal is parenting and the parenting plan, or my number one goal is to keep the house, and so that your lawyer knows what they're supposed to be working towards, and so that you feel supported throughout the entire process, but also it gives them the information so that they can start to prioritize what's the thing that they're going to help negotiate for you, and the things that you can compromise. So it's a really your relationship with your lawyer should really be active, not passive. You don't want your lawyer just to tell you what to do. You don't want to just say to your lawyer, tell me what to do. You really should be an active part of the whole process. And you could say to your lawyer, give me the pros and cons of going to trial. What are the potential outcomes? And having those type of conversations, because what's really important to you might not be important to them if they were in your shoes. So I always encourage really to be more active in that role. So, any